to first start off today by talking about extraschedular TDIU. This segment is going to be about what extraschedular TDIU is, and we want to clear up some of the reputation that surrounds extraschedular TDIU. I think the thinking is that this is a very difficult benefit to achieve. A lot of veterans are deterred from seeking TDIU if they feel like they don't meet the scheduler requirements, and I'm putting that in air quotes because they're not true requirements. So let's talk, Nick, about extraschedular TDIU. And before we do that, I want to first start off with just a primer on what TDIU is in general. So a TDIU is a total disability rating that's based on individual unemployability. And what that means is that if you are successful in proving to VA that you are unable to work due to your service-connected disability limitations, you can tap into a total rating benefit, but a rating that is based on your individual unemployability, and you do not have to demonstrate that you meet the scheduler criteria for a total rating. So a lot of veterans who have experience with combined disability ratings know that VA math can be a challenge, and it can be very difficult to get individual rating percentages and get them to add up to a 100% rating. TDIU is another way to get rated at a total rating for conditions that preclude your ability to obtain or maintain substantially gainful employment. Many veterans do not realize that extraschedular TDIU, as I alluded to before, is still a viable pathway to getting that total rating. A common misconception is that if a veteran does not have the individual ratings that meet the scheduler criteria that's set forth in the regulation that talks about TDIU, then they're somehow precluded from obtaining that benefit. We see this erroneously stated in VA decisions. We see VA really fixate on the scheduler criteria that a veteran has when analyzing TDIU. But the truth is that regardless of what your ratings are, there is a pathway to obtain TDIU if your service-connected disability limitations preclude your ability to obtain or maintain substantially gainful employment. So we'll talk a little bit more about what that all is, what that means. We've got a lot of other content on this too. Let's start, Nick, if I can ask you to talk about the difference between schedular and extraschedular TDIU.
Yeah, so the only real difference between schedular and extraschedular is found in VA's regulation. It's at section 4.16. Subsection A is where they talk about the schedular requirements, and then, which I'll go through in a minute. But then subsection B is where they basically just say, but even if you don't meet those requirements, we will still award TDIU if you can demonstrate, like you said, that you can't work due to your service-connected disabilities. So the schedular requirements in subsection A, you need to have either a single disability rated at 60%. And if you have that, then that's it. You meet the scheduler requirements. Or you need to have at least one disability rated at 40% with a combined disability rating of 70%. So if you meet either of those two things, then that's all there is to it. You meet the scheduler requirements for TDIU. And so then it's just a matter of the VA deciding whether or not it believes that you are entitled to TDIU. Extraschedular, again, on the other hand, even where those schedular ratings are not met, VA will still have to decide whether you are able to work or not due to your disabilities. There are some procedural changes that VA, or some different ways VA processes an extraschedular versus a schedular TDIU claim, but we'll get into that. Ultimately, it's going to be the same substantive focus, the same question of can you work? If you can't, is that due to your service-connected disabilities? So yeah, that's schedular versus extraschedular.
Okay, great. And we'll talk a little bit more, like you mentioned, there are more procedural hurdles to navigate if you are pursuing extraschedular TDIU. And just a couple of notes, because I know I said it before, but I'll say it again. VA commonly says that the scheduler criteria in 4.16a, the regulation that governs TDIU, are scheduler requirements. Talk a little bit more about that, because we see this all the time, I think, at the agency and at the court level.
Yeah, so veterans definitely can't be blamed for thinking that they are actual hard and fast requirements, because one, just the word requirement sounds like that's what it is. And also, a lot of times veterans are going to get an award of TDIU the date that they happen to meet the scheduler requirements. And then, in that earlier time period where they don't yet meet the scheduler requirements, they'll be denied. So, the fact that it just so happens to line up with the date that they they meet the scheduler requirements, of course, you're going to connect the dots and think that that's why. Whether or not that should be the case is, kind of where I get involved, or our firm at large gets involved. But basically, even if you don't meet that scheduler requirement, VA is going to have to just answer the same substantive question, or the same narrow focus of what is your ability to work? What are the impairments associated with each of your individual disabilities, and how, when combined all together, the various disabilities that you may have, whether they preclude employment. The only divergence is that, at least right now, when you don't meet the scheduler requirements, before they grant or before they make a final decision on TDIU, they're going to send it to the director of compensation to make a recommendation, pretty much. And once that director makes their recommendation, then you have to get it back to the board to then determine if they will follow that recommendation. But again, we'll kind of get more into what that recommendation is and some cases that we're working on to try to change that process.
And I definitely want to talk a little bit more about the extra procedural step of the referral to the director of the compensation service, Nick, like you mentioned. And also there's a good amount of case law that helps to show that despite this extra procedural requirement, extraschedular TDIU is still something that VA needs to consider just as well in cases where the merit is there, despite the fact that those scheduler criteria are not met. I think there are a couple of cases that come to mind, Bowling v. Principe, and also Wages v. McDonald's, that kind of safeguard a veteran's ability to be considered for extraschedular TDIU. Bowling talks about the importance of following the process, which the importance of following the process is kind of a double-edged sword. We'll get to that later. But the importance of referring a case to the director if a veteran does not meet the scheduler criteria for consideration of schedular TDIU, but does otherwise demonstrate that they have service-related impairments that preclude the ability to work in a substantially gainful capacity. And Wages also talks very significantly, I think, and this was a CCK case, I believe. Wages talks about how an opinion from the director of the compensation service is not actually evidence in a case. So it's a relevant step, and it's a step that's defined in the regulation that VA has to obtain this opinion or this recommendation from the director as to whether extraschedular TDIU can be granted. But then if that case is being heard at the board, that opinion is not evidence.
Yeah, and I think, so it's a sort of weird little, whether it was a feature or a bug, I'm not quite sure, but regardless, we're left with a situation where the board is remanding the issue of TDIU to the director for their opinion, which can take months or even years before you finally get that opinion and get it back to the board. But then what that opinion amounts to is just, legally speaking, not a lot, which is good if they recommend not awarding TDIU. The board still has to go through the analysis, and if the evidence is there, if the merit is there, should still grant. But then if the director recommends it, the board doesn't necessarily have to follow that recommendation. But that is kind of what leads us to this ongoing case, which a case that we are actually arguing right now, Witkowski v. Collins. So Our colleague, April Donahauer, recently had the oral argument in this case. We're waiting for a judge's decision now, or a decision from the panel of the judges. But in that case, we're basically making the pitch that there is no need for the board to remand it to the director for an opinion. The board should do the analysis on its own and grant TDIU if, of course, if it believes it's warranted, if the evidence is there. But the reason we want to get the judges to say the board doesn't have to do this is so that we can kind of cut out the middleman there in these extra schedular cases, because that really is the only true difference between schedular and extra schedular. Extra schedular TDIU cases are more than viable, but there is sort of that hurdle of that extra time it's just inevitably going to take. So, when you have us repping you for TDIU, we'll be able to handle all of that. But whether you have an attorney or not, it's going to take a long time for an extra schedular case to go through, or even longer than a schedular one. And that can be a problem. Obviously a lot of our clients, a lot of veterans are really dependent on this, and back pay in the future will be great, but it doesn't help right now. So we'll see what happens in that case. If we don't get the outcome we want there, it'll mean status quo. So still, again, viable, still something that can definitely be pursued. But if we are able to get a good outcome there, then that just means the difference between extra schedular and schedular just got smaller than it already is. So stay tuned on that. But
that's a great point. So, and I realize that this is a little bit confusing, because I think we have this regulation that says that extra schedular TDIU requires this added step to get a recommendation from the director of VA's compensation service. And yet the output of that effort is something that case law says is not evidence. Oftentimes these recommendations are negative, as Nick mentioned, so they don't help a veteran. In fact, it's just another voice in the room saying this veteran should not get TDIU. And so, as Nick was discussing with our efforts in Witkowski, that we are watching very closely and hoping for a good result there, we are trying to sidestep that referral. If we are representing a claimant who has a good case for TDIU, who has service-connected issues that prevent their ability to work, but they don't meet those schedular thresholds that are outlined in the regulation, we would like the option to be able to waive the step of going to the director. We would like there to be some choice at VA's level to say that this added step will not help to substantiate the veteran's case for TDIU, which is the whole sort of purpose of getting that development in the first place.
Right. And that's sort of like it. We're not going to get too much into this legal concept of prejudice, but even if you have a regulation saying, oh, it's to safeguard the veterans, VA should do this, if the board can go ahead and say, well, even without doing that, we can give them the entire grant of benefits that they're looking for. It doesn't harm the veteran that they didn't follow this regulation. In fact, it helped them that they didn't do so. So yeah, we'll see how the court weighs in on that. But
exactly.
But yeah, ultimately, I think just the takeaway from this is that extra schedular TDIU is more than a viable path if your combined ratings don't hit those schedular requirements. This might be more of an extreme, like outlier example, but I actually had a case once where I was arguing that it wasn't a client at the agency level of ours, but I was representing her for her court appeal. And I successfully argued that TDIU had been reasonably raised extra schedular TDIU, where the only service-connected disability was a wrist condition rated at 10%. So, in that particular case, there was evidence showing that they weren't able to perform the jobs that they had done prior, which involved a lot of typing. So just kind of an extreme example, again, of even at just that 10%, TDIU was very much on the table there. So,
and that's a great example, though, Nick, because as much of an outlier as it may be, it's important to know, and from our perspective, we've got about 20 to 25% of our CCK cases where we're pursuing TDIU, where the veteran falls under the extraschedular part of the regulation. And that's no small portion of our case inventory where we're pursuing extraschedular TDIU. And what it comes down to, that you mentioned in the case that you highlighted, is what does the evidence say about the person's ability to work given their service-connected limitations? And regardless of this extra procedural step in the regulation and the work that we're doing to try to sidestep that, to effectuate faster decisions and to mitigate delays that can come from the referral to the director process, at the core of what we're doing in every TDIU case is still pretty much the same. We're developing evidence that shows that we meet the legal standard of this client's service-connected conditions preclude their ability to find work and to keep work, and not just any work, but substantially gainful work. And so how do we go about doing that? We've talked about this in a lot of other areas. Solid lay evidence and medical evidence that speaks to the functional limitations that are caused by service-connected disabilities. Vocational evidence in particular can be very important to have a qualified vocational counselor say, I work with people to try to get them rehabbed for work or to get them to be employable. And I'm seeing these limitations as those that would preclude this veteran from performing work in a substantially gainful capacity. I mentioned medical records, but those can be very helpful too, especially for VA. VA does tend to rely on their own VA treatment records and compensation and pension exams. So what facts from those exams and treatment records can we glean that speaks to the person's inability to work because of service-related conditions? If it's just a 10% disabling risk condition, you could think of a lot of different areas where that would impede even sedentary work, like typing and lifting files and things like that. So it's definitely important to be working with a representative on a TDIU case, particularly if it's an extraschedular case, because I think VA is not inclined to grant those as easily. They've got to go through this mess of a process in the regulation. And they also kind of look at these cases as, well, these are lower ratings, so maybe the functional impact isn't there. But those are cases with which we have a ton of experience. And we know that it's not always the case just by looking at the ratings. And that's why the regulation talks about these different pathways, because even a veteran with a 10% for a wrist is still entitled to pursue TDIU.
Yeah. The assumption that lower ratings equate to lower impairment, again, I'm not going to say that that's not true at all, or just the impairments, the rating schedules are meant to be averages. And then TDIU is meant to fill the gaps where, on average, a wrist condition may only be 10%, may only impair you 10%. But if your career has been built on something that requires extensive use of your wrist, again, just to keep using that example, you are going to fall outside of the average for that. So it's really just a fact-dependent thing. You have to look at your own case and think, what are the reasons I can't work? And if you can't work due to things attributed to your service-connected conditions, forget about your ratings and, make that TDIU claim or make that TDIU assertion and, let your representative take it from there if you have one.
Exactly. Great. And then the final thing I will say about extraschedular TDIU, a little bit repetitive, we are going to provide an update once we hear more about what's happening in Witkowski. Another piece that you mentioned, Nick, that's really at the heart of that legal matter is trying to help veterans sidestep any delays in the process that don't serve them, that don't help to get evidence into their file that substantiates their claims. This is a super important concern that veterans have, is how to navigate the process in a way that is efficient, productive, and not a super long wait time. And so that's one of our many goals in pursuing that case. So more updates to come.